Now, here in Ogden, the argument that's made is that by Ogden, that insofar as his New York Grand Monopoly affected his rights in New York waters, and it does, right? They're saying that you can't make this trip over to New Jersey, but a part of that is New York waters controlled by New York, yes? And that therefore this monopoly granted by New York was superior to federal law because of those rights in New York waters. You get the idea here. Well, I started in New York and I'm going to New Jersey, but the federal government's trying to tell me what I can do, and in effect, that affects my rights and my abilities in New York waters. But Marshall answers this congressional power to regulate interstate commerce included the ability, and here's what's important, to affect matters occurring within a state. Now stop and think about that for a second. Within a state, you have got this process beginning where, Ogden has the right to, by New York, the sole right to make this journey between New York and New Jersey. What Marshall is saying here in 1824, he's saying that, look, beginning in New York was the right established by the state for New York to say you had the right. Ogden had this right. But even though it started in New York had no authority to grant the right into New Jersey. So therefore, you can't write law, or in this case, grant someone a monopoly, that is going to affect another state ultimately. So even though it is an interstate commerce issue, it begins in a state. So a state cannot do things, make proclamations or law, that will affect what happens in another state. That's solely the province of the federal government. But this is the first salvo. This is a small little seed at this point that, well, New York can't do things that affect other states. That's where it starts, this idea of activity within a state being governed by the federal government. This becomes broader and less tied to that concept between states, at least not in any sort of discernible way. In other words, what seems to make rational sense in the beginning, because New York is going to affect this ferry's rights to go into New Jersey, gets more and more complicated as commercial activity gets more and more complicated. And when you think about it in the following way, everything that happens in a state, in commerce, is going to reach beyond the state boundaries, right? Not just in terms of shipping, which was the major concern at that point, New York ports, Virginia ports. So people that want to get their goods out to other countries really depended upon New York, not showing favoritism to New York companies and the like. That's a simple idea, and that makes sense. But everything begins within a state. If there's going to be any commerce today, any commercial activity, as it becomes more complicated, begins to involve more than one state. So can any state regulate any commercial power within its state that is going to reach beyond their state? Now, think about a pure market operation here. Companies want to sell to other states. Are we to presume then, based on what Marshall has said, that as soon as it crosses a state boundary, that in effect what you've got is interstate commerce? This is going to get really complicated when we get to things that aren't even products, stuff, physical stuff you can pick up and you can throw. This becomes things like the internet, where there is no physical thing moving. In fact, one can make the argument that the federal government has control over intergalactic, or rather dramatic statement, but activity. Think about cell phones today, right? They go up to satellites. Where are those satellites? They move, right? And the Earth moves. So that is not a product in terms of what we traditionally think of as a product. It's a thing you can touch, a thing you can throw. But now it's nothing like that at all. Can't touch it, can't see it, can't do anything with it. So this has become much more complicated. But we're still in the beginnings of this here, right? We're still looking at the cases prior to 1933. There are things that happened in 1933 that cause a fundamental change here. one of which is the court packing scheme, but we'll get to that. All right. So therefore, Marshall stated that no area of interstate commerce is reserved for state control. No area of interstate commerce. Those things with interstate that affect interstate commerce are not under the state's control. Okay, what about a limit on state power then? The other part of Marshall's opinion in Gibbons, it says New York's right to grant a monopoly, and with whether this monopoly was invalid under the Supremacy Clause. Read the Constitution. Monopolies are not acceptable. And so not only did New York go into sort of tread into interstate waters, but also really doesn't have a right to grant monopolies. So on those two counts, you have an issue, right? So from that first case, from Gibbons until the late 19th century, the Supreme Court had practically no occasion, right, to consider commerce's power under the Commerce Clause. Stops. No other cases come up that require the Supreme Court to look at this. So it's not really until the enactment of the Interstate Commerce Act in 1887, right? So think about where we're moving up towards 1933, so 1824 to 1887. That's a pretty long period of time. And the Sherman Antitrust Act in 1890, that Congress's powers, right, under the Commerce Clause were again seriously scrutinized by the court. It seems that the courts, in the case of Gibbons v. Ogden, gets involved and then just fades away. But then Congress writes the Interstate Commerce Act in 1887, and the Sherman Act in 1890. So now the court is back in the mix again, the Supreme Court. Now they're analyzing and scrutinizing these two particular provisions. So the result ends up being that it becomes much more hostile, the environment, to congressional power than it was in Gibbons. Right? Now all of a sudden things are going to change. We have to make a quick detour, not really off the beaten path here, but it is a slight detour. Think about economic regulation versus police power. Now, police power is the right of the state to regulate. It's not police officers. It's just the right of the government to exercise its powers. So between that 1880 and 1937 period, we've dipped, as I said, into 37 here. We're past that 1933 period, and we now moved into 1937. The Supreme Court reviewed, right, and frequently struck down two different types of congressional legislation premised on the Commerce Clause. The first was economic regulation laws. They start striking those down. And the police power regulation, that is, those that are directed at moral or general welfare issues. So let's look at economic regulation and what that is. The Supreme Court's review of economic regulatory laws from that 1880 period to 1937, right, during that period, is characterized by what's been called dual federalism. And this is an important concept. So the court felt that there were areas of economic life which, under the 10th Amendment, would be left to the state regulation. So think about Marshall. Intrastate affects interstate. Now we're pulling back a bit, right? We're pulling back a bit in response to these congressional Sherman Act and Interstate Commerce Act. The court is reining the federal government in. And other areas of activity which were properly preserved the federal government. These two areas were viewed as being essentially non-overlapping. Either an area was proper for state regulation or for congressional regulation, but not both. One of the two had to be in charge here. So under economic regulation, what are we looking at? Between 1880 and 1937, what the court is looking for is substantial economic effects. That's sort of the foundation of where the court begins. Okay, so during this period, congressional regulation was found to fall within the commerce power so long as the activities being regulated had a substantial effect, right, economic effect upon interstate commerce. Now back up. Remember, the stock and trade here of law are words. So what is substantial? How do we define substantial? What makes something, determines that something has a substantial economic effect upon interstate commerce? And now we get a series of cases and sort of the going back and forth, trying to resolve what substantial means, and then moving into whether or not the court should back off, which it eventually does, which we'll see. But right now the court is very active. It's jumped back into it. Again, you've got Gibbons-Ogden, court gets involved. Interstate activity can be controlled because it can affect interstate commerce, and that becomes very broad. Okay, now you get to the period where there's these two acts, Interstate Commerce Act and the Sherman Antitrust Act in 1890, and what you get is the court jumping back in. So the court's been out of it for a long time. The court has taken a 50, 60-year respite from it. It's not getting itself involved. Now it's back in the mix, right? So this idea of substantial effect. So now we look at the Shreveport rate case. This is a case that really is important, sort of seminal case, the best known case, and a substantial economic effect, what we call the substantial economic effect approach, right, in the Shreveport case. All right, so basically what we have here is, this is 1914, Interstate Commerce, right, the Commission, after setting rates for transport of goods between Shreveport, Louisiana, and various points in Texas, sought to prevent railroads from setting rates for hauls totally within Texas, which were less per mile than the Texas to Shreveport rates. The Commission theory was that Shreveport competed with certain Texas cities for shipments from other parts of Texas, and that the lower Texas interstate rates were unfairly discriminating against the Texas to Shreveport interstate traffic. So you got traffic going one way, you got traffic coming back the other way. The railroads countered, right, that it was beyond Congress's power to control intrastate rates of an interstate carrier. So stop, go back to Ogden. You can't control intrastate rates where there's interstate commerce. If this was Ogden, if this was Gibbons-Ogden, this would not be accepted, right? Because you can control intrastate versus interstate, or its effect on interstate. Now we're getting a little bit more specific here. We're not talking about a monopoly, we're talking about rates, right? So think about it. If a train begins in New York, you pay a certain amount, income. You pay a certain amount for the ticket. Now, you take it all the way to another state, say Connecticut. And now people in Connecticut want to go to New York, but the price of the ticket is different than it is from New York to Connecticut. So the price from Connecticut to New York might be cheaper or more expensive, and the price of a ticket from New York to Connecticut could be more, than a ticket going the other way. So you've got this idea of it's beginning in one state, the train, it's moving to another, as my example, right? Does it make sense? Who controls the cost of those tickets? And the argument here is, well, the interstate, the decision about the ticket in each of these states is an intra, not an inter. It's within the state. It's their responsibility to make the determination. Okay, so the court eventually rejects the railroad's challenge, right, and upholds the ICC, the Interstate Commerce Act in 1887, their right to regulate interstate charges, at least of interstate carriers. It's specific. Now, think about buying things on the internet. That has to go interstate, yes? You take a credit card that's been issued out of Delaware. You purchase something, I brought this up before, you purchase something coming from Texas. They use UPS to get it to you in New York, and yet the courts have said that's not interstate commerce. Pretty hard to get your mind around, the rationale there. But even though the court remains supposed to remain apolitical, one can't help but wonder what the political implications were for the court if it pushed this too far. All right, so the opinion here is the Commerce Clause power necessarily include the right to regulate all matters having such a close, first time the word's used, and substantial relation to interstate traffic, and that it's essential to control, for the appropriate security of that traffic. All right, so the ultimate objective here then was to protect interstate commerce with these, prices of tickets. It's a little bit difficult, in more than one way, to really get our minds around how it could have been this movement back and forth by the court between intrastate affecting interstate commerce or not, and when that would happen. We like clarity around these things, right? But we're really not getting that clarity, right? We're not really getting, or it appears at this point, the clarity that we might need. Okay, so what about the current of commerce theory? Now, there's different theories the court uses. So the current of commerce theory now is going to take a different approach, not one that's divorced from what we've just been talking about, but one that seems to codify it a bit. When we begin to talk about whether it's intrastate or interstate, the fundamental here is ultimately the current of commerce. At any point along the way, can a state interfere with that flow? Think about the trains again. It's a physical idea, right? The flow, the movement. So it's not just whether something happens interstate. Here we're talking about what? Something that completely is contained within one state, as opposed to something that can begin in one state, or the state or a state passively is involved. Because let's say a train from, again, New York goes through Connecticut but doesn't stop in Connecticut. The idea is it's crossed the boundary. And even though there's no direct effect on Connecticut in terms of ticket prices, nevertheless, it is in the flow of commerce. So the current of commerce theory is important because apart from that substantial economic effect, if you think about it, the rationale for sustaining congressional action on that basis, right? You get Justice Holmes developing this idea of the current of commerce rationale, which makes sense. It's not just commerce between states, and it's not just things that begin within one state and make it through to another. It's things that move across states, even though those states may not be directly involved, other than something passing through. Nevertheless, that passing through places it in the current of commerce. And as a result, the federal government has some control. So under this theory, an activity could be regulated on the commerce power of Congress, not because it had an effect on commerce, but rather because the activity itself, right, could be viewed as being in commerce or as being part of the current of commerce. If you look at Swift and Company versus U.S., going back to 1905, you'll get the full story, if you will, behind how it came to be that this idea of the current of commerce begins to become important. Now we go to the other piece, right, which was the police power, if you recall, right? And regulations and the commerce prohibiting technique of police power. So in cases like the Shreveport rate, again, that we just talked about, Congress attempted to regulate local activities directly. But Congress also developed a separate technique. Instead of regulating intrastate activities directly, Congress used the technique of prohibiting interstate transport of certain items or persons. Now think about that. Certain rights or persons. Okay? This commerce prohibiting technique was used not only for pure economic regulation matters, but as a police power or moral regulation. This becomes, think about this idea of morality, right? We've got the courts now deciding what's moral, what's not moral. The court is still finding its way here in some measure with commerce. That's why it's so difficult. They're still working their way around those particulars, right? All right, so the commerce power then prohibiting technique was used not only for pure economic regulation, right, but police power and moral. Okay. And you go back to the first 2 decades of the 20th century, the court was substantially more sympathetic to this commerce prohibiting police power technique than the direct regulation of interstate affairs. So again, the time frame here, first 2 decades. Things are going to happen now, right? Things are going to happen. The most important of which is we're going to go into a depression, right? So here we're looking at the lottery case, right? Which is Champion versus Ames. We refer to it as a lottery case of 1903. Okay, now we're into 1903. We're approaching that 1933 mark where a substantial change is going to be made, and the court once again backs off. So you get the court getting involved, backing off their involvement from 1933 really into the Rehnquist court, and then it re-injects itself back into this process. So the court itself, when dealing with commerce, seems to be of some measure of uncertainty about what their role is, what their place is, what you have a right to control or object to or whatever, the court, and what they need to stay out of. So the majority opinion in the lottery case, right, began with the assumption that lotteries were clearly, quote unquote, remember morality, evil, not by today's standards. States have seen it, lotteries, as a means of stopping organized crime from doing their sort of running numbers and getting involved in gambling of all sorts. Usually, not usually, in all cases there, the federal government was getting no taxes. And this was seen as wrong. Of course, it's couched in terms of it being evil. What we're going to see is that what was evil yesterday becomes a fundamentally acceptable way for the state and the federal government to make money. The lottery is supposed to, those money is supposed to go towards education. Now, some do, but some monies don't. As with all things related to the government, you get administrative costs that end up actually eating up whatever the government was supposed to make in taxes, and then requiring other taxes in other areas to sort of support it. So you have to constantly keep your eye on it. But the point here is that it's evil, right? So therefore, it should be regulated. So since Commerce regulated only the interstate shipment of these evil articles, right, it could not be said to be interfering with intrastate matters reserved for state control. So you're a state, right? Right now, right? If you're buying a lottery ticket, you buy it within a state, even though it's a national lottery. In other words, Powerball and Mega Millions and all that. You get people buying it from all different states in that state. But if you win, the monies you win are really coming from the general pool of monies that have ended up in the coffers because people from different states have contributed to it. So on some level, if it's a government program, if it's a government thing, you've got it becoming nothing more than a tax. Think of it in that way, where basically tax money is taken from all these different states, although the earnings of people are made in those states, and therefore the federal income tax is taken from those states, it goes into a general kitty. And the federal government then gets to spend it any way it wants. So even though you've got lottery tickets from different states at this point, not in a general pool, people are making money, winning the lottery, so they get taxed on it. So that's okay. You'll realize that commerce and the state's right to tax, state coffers, money going into the states, and money going to the federal government, in terms of the right to tax, if you recall, those monies going in are completely under control of the state and the federal government in terms of how they spend that, right? Now, also keep in mind that the federal government doesn't mind the states making money here, because the money that they forego or don't make, they're going to end up knocking on the federal government's door and saying, give us some money because we need money for X, Y, or Z. So to some extent, right, the federal government wants to see the states make money because it means they come to them less. The job of Congress, one of the jobs of Congress, is to take the money that does come to the federal government and somehow, in some manner, try and work it back, at least in part, of course, to their state. So you get money going into the federal government. The object of a lot of politicians is either, if they're in the House, to get money back to their district, and if they're in the Senate, to get money back to their state. So it's all about collecting money from various states and then divvying up that money, regardless of how much any given state puts in. Large states like California will put more money in, presumably. It doesn't mean they get more money out. And that's something we have to kind of think about, but it's sort of well settled. No one complains about that. Okay, or what that money can be used for. So when we look at the regulation of intrastate commerce, then, once it became apparent that the court looked favorably upon the commerce prohibiting technique as a means of asserting national police power, Congress took a significant additional step. It began to regulate intrastate activities as a means of enforcing bans on interstate transport. It's begun. The rationale now, going from Ogden forward, they're moving back and forth, but now it's very clear that the Congress, at least as they see it, has a right to get involved in this, interstate considerations. So here's a good example. This goes back to Hippolyte. Congress passes the Pure Food, Drug, and Drug Act of 1906. We're still before 1933. Acting under the act, the federal officials seized a shipment of adulterated eggs after they had arrived in the state of their destination. Okay? Adulterated eggs, whatever is wrong with them, we don't really know. The right to seize adulterated eggs once they had arrived at their destination was, quote-unquote, certainly appropriate to the right to bar them from interstate commerce, and completes its purpose, which is not to merely prevent the physical movement of adulterated articles, but the use of them. Hippolyte, this is the case, right? These eggs, right, there's something wrong with them. And they've now gone to another state. Not only does it involve the transportation of them, but the control over the consumption of them. So now we've got this thing having pretty far-reaching consequences. Then there's the child labor case, Hammer versus Dagenhart. In the child labor case, now we're at 1918. We're creeping forward to that 1933 mark. The Supreme Court was more hostile to congressional interference with the employer-employee relationship. You see how they're moving into the court is, into a whole bunch of areas here. The justices were particularly unwilling to allow congressional legislation which was pro-labor and which the justice saw as being an unwarranted interference with the free market system. Now think about that. They're getting involved in the economics of it. The court is now determining whether or not particular commerce interferes with the idea of the free market system. Go one step further. One of the things that interferes with free markets is certainly monopolies. But the Constitution does speak to that, and it does speak to the right of individuals to benefit from their own labors in terms of copyrights and patents, that sort of thing. Those things should be applied. But now we're getting into this sort of interesting area where really we're talking about the fundamental idea of open and free markets, or markets, right? So in the child labor case, the court votes 5-4, so it's a split decision here, to strike down a federal statute which prohibited the interstate transport of articles produced by companies which employ children younger than certain ages or under certain conditions. Police powers. We're moving into, remember, we're in police powers here, which has a moral bent to it, right? A moral sense to it. Hey, you can't have these children, very young, actually go out and produce these products. It's a violation somehow. So the rationale here is that, based on the majority of the court, the 5, it distinguished this statute from other police power commerce prohibiting statutes, which the court had upheld. In those cases, the court argued the interstate transportation being prohibited was part of the very evil sought to be prohibited. Prohibition of interstate shipment of lottery tickets and the like. Here, by contrast, the goods shipped in interstate commerce were themselves harmless, right? It was only the employment of child labor which was an evil. The things they produced were not the problem. It was that they were producing them. And this employment was not directly related to interstate commerce. Children making the products, but not directly associated. So under the powers being reserved to the states, the majority reasoned that if a prohibition on interstate commerce were permitted, all manufacturing intended for interstate shipment would be brought under federal control, encroaching constitutionally on the authority of the states. They get there. That's what they conclude, right? In terms of child labor and the like. Now, Holmes has a dissent, and oftentimes you'll find that yesterday's dissent becomes tomorrow's majority opinion. Dissents are very important. People want to read the majority opinion, and because that wins the day. But those that dissent have a different approach or a different interpretation of things, and that oftentimes makes it very interesting to look at because, in many ways, it points out issues and problems of the court's decision, but also offers alternative approaches or ways in which you might want to think about that issue that can bear fruit later on. So don't ignore dissenting opinions. You can't blow by those. I'm not saying for this class we really want to focus on those majority opinions only because this is not, you're not in law school here, right? So Holmes' dissent, and it was a classic dissent by him, that in the long run, this idea became the more significant opinion in Hammer. Holmes argued that so long as a congressional regulation falls within power specifically given to Congress, you have the power to regulate interstate commerce, right? The fact that it has a collateral effect upon local activities otherwise left to state control does not render the statute unconstitutional. Just because it has far-reaching consequences that reach into the state doesn't mean it's unconstitutional. The 10th Amendment of no force. Thus, Holmes' dissent implicitly rejected the 10th Amendment as a source of limitation on federal authority, so long as congressional action technically comes within the constitutionally enumerated powers. It is valid, here we go, no matter how substantially it impairs the state's ability to regulate that would otherwise be local affairs. Right? So it's a highly restrictive view of the 10th Amendment, but that became the majority view beginning in 1937. Now we're across the 1933 line, right? And it continues really pretty much to the present. So we reached a pivotal point here where we see this change. And it really begins with the New Deal, which obviously has a major effect on us moving forward. But there are key parts to this, right? So the New Deal, which was meant to deal with, obviously, economic issues, right, 1933, right? The Supreme Court's view of congressional power under the Commerce Clause stood, right, in an ambiguous state. In other words, it was unclear, right? The state, quote, commerce prohibiting, close, technique was of doubtful validity here, right? Commerce prohibiting, in the view of Hammer and Dagenhart. The validity of the, quote, effect upon commerce, close quote, rationale was unclear. In the Shreveport case, right, it indicates that the intrastate activity having a substantial practical effect on interstate commerce could be regulated. But other cases suggest that there must be a, quote, direct, close quote, and, open quote, logical, close quote, relationship between the intrastate activity being regulated and interstate commerce. There's got to be a connection. The court's wavering. Within a few years, it became apparent that the direct and logical requirement would carry the court and that a majority of the court would strike down congressional regulations of any area which the majority felt was reserved by the 10th Amendment to the state control. The thing about commerce that's so difficult is that it goes back and forth. court's involvement based on one thing, the court steps back based on another, the court comes forward and gets involved again on yet another. So it's moving around. And so following it's important because you get to see the thinking of the court. Ultimately, the court is about to bow out again, right? So in the Schechter poultry case, right, what we call the sick chicken case, right, the decision which caused the greatest public uproar during the New Deal was Schechter, right? 1935. We're past the 1933. At issue in the case was the validity of National Industrial Recovery Act, the NIRA, which authorized the president to adopt, ready, open quote, codes of fair competition, close quotes. Code of fair competition, and it's the president to adopt those, right? For various trades or industries, the codes regulate such items as minimum wage and prices, maximum hours, collective bargaining. If you look at Sullivan versus and Gunther, you'll be able to see how that plays itself out. When you look at the cases that you're going to have that will be sent to you, you have to think of commerce as it progresses past within this time frame, but also how these cases I'm mentioning move back and forth and influence the way the court acts. So, okay, here's what's going on in Schechter. It involves conviction of poultry, right, Schechter, on charges of violating the wage and hour provisions of the New York metropolitan area live poultry industry fair competition code. You got that? All right. Although the vast majority of poultry sold in New York came from other states, Schechter itself bought within New York City and resold its stock exclusively to local dealers. It's interstate. They sell to local dealers the chicken they have that comes from the state. And the act is held unconstitutional. The Supreme Court held the NIRA unconstitutional as it was applied in a way to Schechter. Why? It's not in the current of commerce. Schechter's activities were not within the current or the stream of commerce because the interstate transactions ended when the shipments reached Schechter's New York City slaughterhouses, unlike cattle in the Swift case, as later on, which were ultimately reshipped out of state after being slaughtered. Now think about this. So it happens interstate, we grow them, we sell them to interstate companies. Do they then sell them outside the state? Or does the fact that those chickens are there mean that chickens from other state that are trying to be sold in that state are not being sold? You'll see with the wheat case that this is the argument, that the very fact that you're producing chickens here, even though they're staying within your state, means that your state's not going to buy chickens from outside of it. This is also, if you think about it, the mindset and the concern around international trade. I'm not going to get into the economics of it. We're not going to get into the economics of comparative advantage and all of that. But nevertheless, that's the idea. And they decide it's not affecting commerce, nor was the affecting commerce rationale applicable, right? What was required was a direct, not indirect effect on commerce. Now we're back to that. Okay. Then we get to the Carter Cole case, and now we're in 1936. Remember what's going on in the country. The court is not immune to the times in which the court decides cases. The court understands what's going on in the real world, and they have to take that into consideration in some measure, right? Here, the case for the government, right? So the decision in the Carter Cole case was not as damaging as popularly perceived. We're talking about, Schechter here. A much more significant blow to the New Deal was delivered in the Carter Cole, decision in 1936. Keep in mind now, you notice in the last two cases we talked about the New Deal. You're going to find that what happens here is that the president, Roosevelt, by FDR, is frustrated by the court. And what he wants to do in the court packing scheme is get justices, add to the number of justices that are going to make, decisions that will support his policies, right? And so here what we're looking at is frustration building in the executive branch over these decisions. Okay, it's held, right, unconstitutional, right? Carter versus Carter Cole. The act was found not to be valid use of the commerce power. The court returned to the distinction espoused in its Knight case between production and commerce. Now production, right, which was being, happening in that state. Nowadays, nothing happens in the state. Even producing cars comes from all over the place, right? Tires from here, generators from there. Well, not anymore. Alternators and batteries and the like. Okay. All right. So production, which was what was being regulated here, was a purely local activity, even though the materials produced would nearly all ultimately be sold in interstate commerce. So, okay, you can tax, or the federal government can get involved as soon as the product is made and it's moving. But while it's being made, that's totally interstate, and the federal government must have hands off. Nor did the production directly affect interstate commerce. The issue was not the extent of the effect produced on interstate commerce, but the existence or non-existence of a direct logical relationship between the production and the interstate commerce. Now we're looking at, did that production influence interstate commerce? I just said that if you think about chickens, right, being grown and raised and eaten in the state and not leaving, it still affects the amount of chickens that state's willing to take from other states because they have enough chickens. Right here, we've got it's sort of going the other way. We're doing the stuff in the state, but it's going outside the state. You still can't touch the people producing within the state because the production is totally within the state. Now, we're not making an exception here for parts and the like that come in to assemble or whatever. What's going on there, that's going to change, right? Because that's going to also be in the flow of interstate commerce. But right now, the court's argument is no. Then we come to the Cardozo dissent. Again, dissent becomes important. The majority opinion did not give separate consideration to the validity of other aspects of the act, such as the setting of minimum and maximum prices on coal sales. The majority viewed these price rules and the wage-hour rules as being inescapably intertwined, so that the invalidity of the latter made the entire act invalid. But a dissent by Justice Cardozo contended that at least the price rules were valid, even as applied to intrastate sales. He argued that the prices of intrastate coal sales had such a direct impact on those for interstate sales that regulation of the latter would not be successfully carried out with regulation of the former. Right? Justice Brandeis and Stone joined the dissent, and Chief Justice Hughes agreed in a separate opinion that the price regulations were valid. So at least on the price issue, the decision was a narrow 5-4 one. Right? So again, you've got to read that case to get a fuller picture. All the cases assigned. Now we get to the heart of the matter. The Carter decision was really a body blow to the New Deal, since it implied that all attempts to deal with what the court perceived as local problems, including probably all employer-employee problems, would be struck down. Roosevelt waited until after the 1937 election, wanted to get reelected, to launch a counterattack. When he did so, it was principally in the form of the infamous court packing plan or court packing scheme. He wants more judges, more justices, so he can get more favorable decisions for the plans that he wanted to put in place, the economic plans. All right. So Roosevelt's proposal sought congressional authority for him to appoint an additional federal judge for each judge who was 70 years old and had served on the court for at least 10 years. We're revisiting this now in current terms here in 2020. The plan was to apply to all levels of the federal judiciary and provided for a maximum of 15 members on the Supreme Court. We're moving from 9 now. So that's an additional 6 members. That's a rather large increase. All right. His plan's defeated. So the court pushes back, right? Or it's going to push back. This caused, his attempt caused, enormous political controversy, just as what's going on now, should the Democrats actually try and increase the number of justices in the court to make the court more liberal or what have you. Those opposed to it contended that, quote, its practical operation would be to make the Constitution what the executive or legislative branches of the government chose to say it is, and an interpretation to be changed with each changing administration. That's exactly the argument made today, because that is the argument. Now the next administration comes in, of the other party. So the Democrats increase the number. The Republicans then increase the number. Pretty soon you've got a court that's completely comprised of political justices. Okay? And this becomes really a problem. So the practical effect here is that by the time the Supreme Court had materially reformed itself, the retirement of one of the justices, Devanter, was enough to form a new majority, and the court decided the important National Labor Relations Board v. Jones, the NLRB, versus Jones and Laughlin, in favor of the validity of the NLRA. All this occurred while the debate on the court packing plan was still in progress. Thus, President Roosevelt made a plausible claim to have lost the battle but won the war. Got what he wanted, but didn't get it the way he wanted to get it. This now leads us to the modern trend, because now we're past 1933, we're into 1937, and here the modern trend, generally in the Supreme Court Commerce Clause analysis for us, begins in this 1937 case in the NLRB. Beginning with that case, the court showed a vastly greater willingness to defer to legislative decisions in matters of economic nature. Under the present doctrine, the court will uphold commerce-based laws if the court is convinced that the activity being regulated, quote, substantially affects, close quote, interstate commerce. And the Congress and the President are going to make an argument that, in fact, that's what it does. All of what they do. In fact, the only case since 1937 has the court found that Congress went beyond its mere Commerce Clause powers was the Lopez case, right? And now there's three theories that sort of begin to formulate here. The first is that the court expanded the reach of the commerce power by recognizing those theories, right? The first is going to be an expanded substantial economic effect theory. Two, a cumulative effect theory, right? We're going to go over each of these. And three, a commerce prohibiting protective technique. All right, so the expanded substantial economic effect. Remember that this idea of direct and logical relationship between the intrastate activity being regulated and interstate commerce, right? And keep in mind the NLRB versus Jones, right? The court substantially loosened the nexus required between the intrastate activity being regulated and interstate commerce. It begins to open that up in terms of saying there's less of a difference between those two than the court has said there's been in the past. So this substantial economic effect gets expanded. So the court insisted upon a direct and logical relationship between the intrastate activity being regulated and interstate commerce. But beginning in the NLRB, right, the court substantially loosens that nexus required between that activity and so on. So when we look at the Jones-Laughlin case, we look at the NLRA, right, being upheld, we can conclude that the multi-state network of operations, right, the court concluded that labor stoppage of the Pennsylvania intrastate manufacturing, which goes back to those states, operations would have a substantial effect on interstate commerce. Therefore, labor and the Pennsylvania plants could constitutionally be regulated by Congress. The court is finding an argument here. The court is refashioning its thinking. The court is restructuring the relationships to take these commercial activities and place them back in the hands of Congress and provide the president to execute them, and staying away from being involved in these decisions simply because of the court packing scheme. And it was a shot fired across the bow of the executive branch, and Congress also slapped the president down for doing that. So keep in mind that the current of commerce, remember that, Rationale, don't need it anymore. The court expressly declines rely on the current commerce theory. The court indicated that current of commerce cases, right, Swift and others, were merely particular, not exclusive illustrations of the commerce power. Particular, not exclusive. Okay? The 10th Amendment was rejected now as a limitation. The court implied, though it did not expressly state, that the 10th Amendment would no longer act as an independent limitation on federal commerce clause. That's important. They're now taking a piece of the Constitution, that 10th Amendment, and saying it really doesn't come into play here. They're backing away, right? So what are the practical consequences? The abandonment of the current of commerce, right, rationale, remember that? That began back with Jones, now makes it irrelevant. It's not irrelevant anymore, whether the activity being regulated occurs before, during, or after interstate movement. That's now off the table. So long as the regulated activity has a substantial economic effect. We're back to trying to define substantial. That's Congress's job. Upon interstate commerce, that activity may occur substantially before the interstate movement, the steel production in Jones, Laughlin, and so on. Case, you've got to read these cases. And then the practical consequences, the last part of this, is the effect must be substantial again. And you should look at U.S. versus Lopez to see how that's defined. So there's been a switch here. There's been a movement away from the court being involved in things based on this, sort of flow, all right, and the substantial effect. This now brings us to that second theory, right, where we talk about, we broke it down into the three. And so now we're trying to get our minds around each one of those to understand how the court sort of has pieced together its current powers. The cumulative effect theory, right, is another expansion of the Commerce Clause power, right, again to Congress. The cumulative effect theory is just what it sounds like. Provides that Congress may regulate not only its acts which, taken alone, would have a substantial economic effect on interstate commerce. So this idea of substantial now, we've got this other theory saying it's not substantial, it's cumulative. But also an entire class of acts. If the class has a substantial economic effect, even though one act within it might have virtually no interstate impact at all, as a result of this cumulative effect principle, it is not only the type of regulation sustained in Jones, regulation of a large steel producer, right, which may be regulated, right, based on a substantial effect. So it's a cumulative effect, right? Not a substantial effect. We're not looking at quantity, if you will. We're looking at the connection, the addition of all the effects as they accumulate. That's what regulates, for the court, regulates commerce. It's not so much, a substantial effect. Now it's that one piece is problematic. It's adding all the other pieces together to come up with what's problematic. All right? There it's Wickard versus Filborn in terms of establishing the cumulative effect principle. And you should read that case because it's an important one because it establishes this cumulative effect. Right? I'll give you some background so you have a feel for it, but it's one of those cases you need to read. All the cases that are being assigned you need to read because they deal with these very complicated machinations, moving back and forth based on all kinds of issues. In Wickard versus Filborn, right, Wickard involved the Agricultural Adjustment Act of 1938, which permitted the Secretary of Agriculture to set quotas for the raising of wheat. I've mentioned this already, right, so here it is, on every farm in the country. The act allowed not only the setting of quotas on wheat that would be sold interstate and intrastate, but also quotas on wheat which, and here we go, would be consumed on the very farm where it was raised. Okay, so under the cumulative effect, what they're saying here is, I grow wheat just for me and my family. We get it, we harvest it, we grind it up, we make bread. Only we are consuming it, my family, right? But even though it's just for consumption of my family, that means my family is not buying wheat from someplace else. And that cumulatively affects commerce. Take a second, take that in. It's like you are making your own for just your family, but now in this case here in Wickard, that's fine, but it's not allowed. Okay? Phil Byrne, obviously the plaintiff in Wickard, owned a small farm in Ohio. He challenged the government's right to set quota on the wheat which he raised and consumed on his own farm on the grounds that this was a purely local activity beyond the scope of federal control. Now, if anything seems like it's a violation of someone's, rights here, even though it's termed, it's framed in other terms, this might be it, right? But the statute is upheld. And why? A unanimous court, whose composition had changed radically from the days of Carter Cole, a case just 6 years before, upheld the act, even as it is applied to home-consumed wheat. The court reasoned as follows, ready? The consumption has market effect, which we just talked about, and there's a cumulative effect. It affects the market, and then if you have one farm do it, and another farm do it, and another farm, the accumulation of that is a problem. By the way, it's still good law, right? In 2005, the court relied extensively on Wickard in dealing with Gonzalez, another case, and so on. So this commerce prohibiting technique, police power regulation, right, that you have to recall that apart from the affecting commerce here in a line of cases, in another pre-1933 line of cases, the Congress right to use prohibition on interstate transportation of items or people in furtherance of its police power. Remember, there's a moral component here, or general welfare. It's expanding at an exponential rate, what Congress controls in terms of commerce, right? All right. Darby, reverses Hammer, and you should look at the Darby case. It's one of the cases you have to look at. Dealing with, in Darby, the minimum wage regulation is upheld. Today, the federal government sets the minimum wage and it's set to really the poverty level, and states are allowed to go above that if they so wish. What's important here, when you think about it, is in these issues, the federal government sets a floor, not a ceiling. So here's the minimum wage, federal minimum wage, and it is typically, and I don't know about all states, but I can't imagine not, they'd get a flood or an exodus of people leaving to go to higher wage states. It's a floor, and most states have their minimum wage requirement above that. So it doesn't violate the federal law. It exceeds it, which is okay. So the direct ban in Darby is upheld. All right, the 10th Amendment now becomes irrelevant, right, over interstate commerce. And the motive around it being, irrelevant is that the court disavowed any interest in Congress' motive. In other words, and here's the quote from the court: the motive and purpose of a regulation of interstate commerce are matters for the legislative judgment, upon the exercise of which the Constitution places no restriction, and over which the courts are given no control. They've moved away. Congress handles this, right? The present rule is that it's irrelevant, right? The motive. It remains a feature of the Commerce Clause, and it has a lot of constitutional analysis that says they can go ahead and do it. All right, so a case that's also important here, again, is Lopez, which you should really look at. And I want to go to the Violence Against Women's Act Morrison case. The president-elect at this point, Vice President Biden, led the way here on this. And really the court rejects it. So now we're in 2000. We're going to begin to see the court re-enter the arena of commerce. This case is important because it really shows the present mind at that point of the court. All right, so in 2000, an important 2000 case suggests that Lopez will be a major obstacle whenever Congress relies on its commerce power to regulate conduct that essentially is non-commercial. commercial activity is fine. If it's non-commercial, you can't. So just as Lopez held that Congress can't ban gun possession in schools, this, the U.S. versus Morin case broadly regulates violence against women. Well, here are the facts. In Morrison, Congress was concerned that the state's judicial systems were not taking gender-motivated violence against women sufficiently serious. Congress therefore passed the Violence Against Women's Act. And this is, okay, the act announced that all persons within the U.S., quote, shall have the right to be free from crimes of violence motivated by gender. That is very, very broad because, and I shouldn't say very, very broad. It's difficult to discern, and more importantly, it seems to be a given, right? That women would have this right. To enforce that right, the act then said that a woman who was a victim of such a gender-motivated violent crime, as it's defined, whoever's defined, could bring a civil suit against the perpetrator in federal court. Okay, so here's the particulars. A female student at Virginia Tech who said she had been raped by two members of the school's football team sued under the act, right? They defended by arguing that the act was beyond Congress's powers, including its commerce powers. So what's the court's holding here? 5-4, so it's a split in Lopez, right? The court agreed that the defendants that the act was beyond Congress's commerce power. The majority opinion by Chief Justice Rehnquist, remember the Rehnquist court before, relied principally on the fact that the activity being regulated was essentially non-economic. The court's okay if you're in the economic sphere. Congress takes it, president fight it out. But this is non-economic. And so the court's willing to jump in again. So, quote, gender-motivated crimes of violence are not in any sense or of the phrase economic activity. While we need not adopt a categorical rule against aggregating the effects of any non-economic activity. Thus far in our nation's history, our cases have upheld the Commerce Clause regulation of interstate activity only where that activity is economic in nature. So here's the Congress's findings are not enough. This is important. Rehnquist conceded that here, unlike in Lopez, there were detailed findings of Congress detailing the effect of the conduct being regulated on interstate commerce. For instance, Congress had found that gender-motivated violence deterred potential victims from traveling interstate or from being employed in interstate business. Now stop and think about that. If a woman that lives in a state, forget that it's obvious that violence against women is in Congress is obviously a criminal act and is punishable by law. But what they're saying here, they're trying to say, if a woman is assaulted, we're going to protect women here even more. And so if a woman is assaulted anywhere in a state, then that woman and other women may not want to go into that state and purchase things, or may not want to work in that state, may not even want to buy things that come from that state, right? So therefore, we're going to protect women and say that if you commit a violent act against a woman, you're in violation of the Commerce Clause, and therefore Congress has control over that, right? However, Rehnquist seemed to give virtually no deference to these findings because they made for too attenuated a causal claim. Quote, if accepted, this reasoning would allow Congress to regulate any crime as long as the nationwide aggregated impact of that crime has substantial effects on employment, production, transit, or consumption. Indeed, if Congress may regulate gender-motivated violence, it would be able to regulate murder or any other type of violence. This is a non-economic activity, crime by its nature, right? And then they make the local versus national distinction. You really should look at the Morrison Lopez cases as well as the other cases that have been given to you, because those cases really make clear the court's movement here, going back and forth between how the court's going to deal with things. So what we have here is in 1937, the beginning of the court sort of trying to assess where it where it really belongs in all of this. Okay. This brings us to the summary of the modern view, right, which is channels, instrumentalities in terms of affecting commerce. So here, the modern court's view right, in light of Lopez, there are four broad categories here. First, those that are in the channels of commerce, right, can be regulated. If they're in the use of interstate commerce, is in the use of those channels, means, ways you get there, waterways, roads, whatever, the commerce can regulate in a way that is reasonably related to highways, waterways, and air traffic. Has to somehow have an effect on those things. Then there are the instrumentalities of it. That's the second thing in terms of the modern view. Commerce can regulate the instrumentalities of interstate commerce, quote, even though the threat may come only from intrastate activities. Look at Lopez again. And this refers to people, machines, and other things. Those are the instruments that make products, right? Capital and labor. That's what it really comes down to. People, machines, and other things. Then we have the third, articles moving in interstate commerce. It's just the movement, right? Articles that are moving in interstate commerce. The court said that computerized information about motorists was an article of commerce, whose release into the interstate stream of business made the information an appropriate subject for congressional regulation. This is very difficult to get one's mind around, given where the court ends up on all of this. And they come back to this idea of substantially affecting commerce. This is the most interesting of the lot here. Congress may regulate those activities having a substantial effect on interstate commerce. You look at Lopez again. The idea here is, do you have a way in which to make a consistent argument for and structure for dealing with commerce? The problem here is that commerce gets so complicated because it keeps expanding. In other words, different things come into the flow of commerce. That being the case, how do you adjust and come up with ways in which you can, have the court and the Congress and the president deal with what is and what is not commerce, and in dealing with its impact, and what can states regulate, and what does the federal government get to regulate, and what should the court be involved in, and what should the court not be involved in? The court says, hey, if it's economic, we're involved, and then it says, after 1937, well, if it's economic, we have nothing to do with it. It's in the legislative body. Then it says, well, if there's an economic impact, but it's fundamentally not about commerce, it's a non-commerce issue, like in Morrison, that basically we can get involved in that. Then it goes back in the modern view to be looking at, in totality here, in summary, the modern view, they're struggling to come up with something that makes sense. One of the arguments for more justices on the court is that you need you need people that are more specialized in various areas of commerce. You need people that understand the technology. Now, I would make the argument that that's not what the court needs to do. That's what witnesses do. That's what attorneys do in presenting their cases. And that all of those intricacies, once understood by the court as given to them by both sides in a case, they make a decision about, based on that and the outcome, whether there is a constitutional component here or there isn't a constitutional component. You can't have enough justices to cover all the areas of commerce and keep expanding the court to bring in more and more experts on the ever-changing state of commerce. You got private companies now flying people, into outer space, and then bringing them back. Who covers that? Is it? It's clearly not Air Force, right? It's not commercial flight. It's something else. It's commercial, but who regulates that? The Earth spins, the thing goes up, it comes down someplace else. So if it returns where it came from, there are other maneuvers. Who governs that? What about safety measures? Should Congress be talking about safety measures or not? Now, there are other cases like the National League of Cities and Garcia versus San Antonio Metropolitan Transit Authority. Any case that I give you that's going to come through in the packet, that's in that packet, you're responsible for understanding the issues, understanding the facts of the case, understanding how the court decides. We care about the issue, the facts, and the court decision, because the facts support the issue and the court addresses the issue, and then we get some understanding about how the court looks at those sorts of issues. And that's fundamentally what's most important here, is to get to that point where we understand this very complicated commerce power of the federal government. And so it gets more and more complex. And one of the mechanisms, I mentioned this before, that the federal government uses, it's a lot easier to give the states a choice to support federal arguments or federal policies by using their tax and spend authority, the federal government, because once they collect those tax dollars, they can spend them any way they want. So we want states to do X, but that might violate some constitutional principle because the federal government doesn't have a right to do that. But what about if we just say, we're going to give you guys some money in the case of roads, right? We're going to fix the roads for you, give you money to fix your roads, or give you money for this or that, so long as you raise the drinking age to 21. You don't have to, but we're not giving you money if you don't. They have a right to spend it. The state has a right to say, no, we're rejecting that. But what state's going to reject getting money from the federal government? So what the federal government has realized is, and it really serves the purposes of Congress anyway. They want to bring money back, remember? Well, we're going to give you money to do X. So now the Congress folk can say, look, we brought money back, take care of the roads. But if you're 19, you can't drink, right? Drinking is not a right. Voting is a right. Okay, equal protection under the law means that at one point, if you could be drafted into the armed services, you should at least be able to vote. So the voting age came down to 18, because that's what the draft age was. Now, if we're going to ask you to risk your life for the country, then you should at least have a right to vote for those that are making those decisions. Drinking, however, is not a right. And they could argue that it's a safety issue and so on, but it doesn't even matter. The federal government doesn't have to make an argument. They can simply say to the states, hey, if you want these funds, you can spend them, but you got to raise the drinking age in your state. Now, the rationale behind the states not cheating, Connecticut again says, okay, we'll do it to 21. We'll get that money. New York says, we don't want the money. People in Connecticut will just go across lines and they'll buy liquor. Now, if they come back into New York, are they in violation of the New York law? Commerce is sloppy because it encompasses so much of everyone's life that it is very hard to make the argument that, it's up to the federal government or the states. We tend to move with the tenor of the times. Of all the things we've covered, commerce is the most complicated and is the most important power of Congress because they can control the economic activity that takes place. And in a capitalist economic structure, that's really important, right? We're moving into an age now where corporations and economic entities have been given so much authority to do what they want by exempting them, Rule 230, right? Exempting them from any kind of suits that the average citizen might bring against them. They're free to do whatever they want, really. And so you get major tech companies that can control information. And once you control information, you control the basis of people making decisions about something. And once you control by giving them a narrow swath of information, the problem is, are they really making an informed decision? And I'm not just talking about voting. I'm talking about how people feel about a particular thing. It's a lot of power. And that's one of the major arguments today is how much power do we give these companies that have or could capture information and disseminate it in whatever way they like? Does that give them too much power? For good or for evil? Should they have that kind of power? And regulations that have been set up through the campaign finance laws, these companies benefit. And that's not something we'll go into here. But you should know that when the Commerce writes rules or laws or regulations that protect company from any kind of scrutiny or lawsuits being brought against them, they're free to do a lot of stuff, and that could be have a very negative impact on the whole idea of freedom and so on and so forth. One of the major concerns is always getting enough information out to people to make informed decisions. Not just about elections, that's important, but about products, about what they find acceptable in terms of production of various products and the like. Economic advantage could be given to some players in an industry over other players, creating barriers to entry into that field. Look, in a capitalist society based on open markets, there must be an open market in all areas of commerce, whether it's technology or whether it's hot dogs. It doesn't matter. When you close the market down and give an opportunity for people to make a great deal of money because a monopoly has been formed, that's dangerous. During the present day that we're in, a perfect example of this would be Amazon. Since the pandemic started, or things began to happen back in the beginning of 2020, Bezos, right, who owns Amazon, has increased his wealth by some between 79, here are different numbers, $1 billion. Increase his wealth. Because of the structure of the pandemic, this person has a lot more money now. There's no one that really competes against him. And that creates monopoly opportunities that make people very, very wealthy. And this has been the history of those who have done very well. From the outset, new technologies come or a new idea comes, we want that. But then when it begins to capture markets, there's a need for regulation, which would form under commerce. But if those players are giving lots of money to Congress to run for office, there's less of a likelihood of biting the hand that feeds you. So Congress gives exemptions and so on and so forth. So I would argue that the corruption of the commerce power comes back down to campaign finance laws, which make our elected officials dependent upon money, and those that have the most money, they depend on more, which means they influence the process. So commerce is really important on many, many different levels. And it impacts not only the cost of things, but also the fundamental democratic principles that a capitalist republic like ours is based on. Okay, that's the final lecture of the semester. There will be cases coming to you, if you don't already have them, that you should read over and put in the context of what we just talked about. You can get that, of course, from your text and be able to piece together what you need to prepare for the final exam. Obviously, we're going to be focusing on those areas that we spent the most time on. And when it comes to Congress, it's taxing and spending, right? It's going to be the federal commerce power. Those things are important. Those things you should spend a lot of time sort of considering and taking a look at. And ultimately, if you can manage all of that, you'll be fine in terms of, and the general powers, of course, of the legislative branch. You should be well prepared for the final. So that ends the final lecture for the semester. You'll get those cases if you don't already have them. You've already taken the midterms, so you have some understanding how this all works. And so good luck on the final.